So welcome to CPD4Me. We provide practical and relevant training for busy professionals. My name is Bronwyn Pott, and today we've got a substantive law update. We work in a pretty fast-moving and changing environment, and that includes the laws that we work within. Our aim is to bring you recent case studies, precedents, as well as updates so that you're able to stay on top of your game.
Today, the primary topic we're going to cover is Section 54 of the Insurance Contracts Act, which has created some complex case law on a provision about when an insurer is entitled to refuse to pay claims altogether and when, under the provisions of the statute, it is not entitled but can reduce the amount of claims. The decision in 2016 on this topic was one of the full federal court in Watkins Syndicate 0457 at Lloyd's against Pantaneous Australia Proprietary Limited. This case involved claim for damage to a yacht which had cleared Australian customs for the Fremantle-Bali race, an ocean race, and on the return voyage it struck a reef near Darwin just before re-clearing Australian customs. However, it was within the territorial limit of the Lloyd's policy at the time of casualty. We now turn to the operation of another provision of the Insurance Contracts Act, Section 45, which is colloquially known as the other insurance provision. And that provides that where a provision has the effect of excluding or limiting the liability of the insurer by reason that the insured has entered into some other contract of insurance, the provision is void. The decision we're going to look at again is a decision in 2016, but this time of the New South Wales Court of Appeal in December 2016 in Lambert Leasing and QBE Insurance. Now, again, this involved a tragic set of circumstances. An aircraft crash in which all aboard were killed. Lambert had sold an aircraft to two partners who leased it to a third entity. The aircraft crashed, all aboard died. This occurred in the United States, and their relatives sued in the United States for compensation. An insurance policy with Global responded to a claim by Lambert for the defence of the US proceedings, including costs. And at the time of the proceedings in New South Wales, the Global policy continued to provide indemnity. Subsequent to the acceptance of risk, however, Global and Lambert discovered that there was a potentially responsive QBE policy on which Lambert was nominated as having coverage, and that policy had been taken out under contractual obligations in the sale agreement. That's the aircraft sale agreement.
I hope you enjoyed this session today from CPD4Me. Continuing professional development should be about learning new things, about challenging yourself to learn and grow, about finding better ways to do the things that you do every day.